Hello viewers, welcome to my channel. I am Hasham here. Now I am going to continue our discussion, our lecture on management of companies and meetings. This is the topic I have selected for business law subject. Last video I have started the topic of management of companies. In the last video I have explained the meaning of the term director, qualification and disqualification of directors. That I have discussed in the last video. Continuing the topic, in this video I am going to explain you about the position of the directors and appointment and removal of directors. So three topics I am going to discuss in this video. The first one, position of a director, appointment of a director and removal of a director. So watch the video till the end to get a complete command on this topic of business law subject. So already so many videos I have uploaded on Indian Contract Act, Sales of Goods Act. If you have not watched, I suggest you to go to the playlist of my channel. Select the subject business law. Watch the other laws like Indian Contract Act and Sale of Goods Act. Then we can start this Companies Act 2013. Now I am starting with the topic position of a director in a company. What is the position of a director in a company? Very frequently asked in examination this question. What is the position of director? See, the real legal position of the director of the company is not an easy task to define. Law has not specifically given what is the position of a director. It's very difficult to define the position. Very important position, very crucial position occupied by the directors. Then what actually we can see what are the functions the directors are performing. Accordingly, we can explain the position occupied by the director. Mostly they are considered as agents, trustees, officers of the company, managing partner. So different ways we can be able to define the position of a director. But every position will give one of the function of the director. So the directors may be said to be the trustees, to be the agents, to be the officers, to be the managing partners, etc. But all these statements are not being used to define completely the powers and responsibility of directors. Whatever we are explaining now, I am writing now, this only explains some of the functions performed by the directors, not complete functions and responsibilities of the directors. The position of directors in different forms are as follows. So one by one I will explain you. First of all, directors are agent of the company. See, a company is an artificial person created by law. A company does not have physical existence just like an individual. So the company itself cannot perform all the functions. There should be some natural person to perform the functions of this artificial person. The artificial person is company cannot do itself. So somebody must be there to perform the functions of the company. So here directors are the persons who are to perform the functions of the company. So we can say from this point of view, directors are the agents of the company. The relationship between the company and the directors are that of principal and agent. The principal is the company and agent are the directors. The directors have to perform only those functions which are specified by the principal, which are specified by the company. So directors cannot do anything which is against the company. It is ultra vires act. Any act of the directors beyond the powers of the company is called ultra vires act. In that case, the directors are responsible. Company is not responsible. Personally, directors are responsible. That's why the directors have to perform within the ambit of the powers and powers of the company. So in this way, the directors will be called as agent of the company. The directors will be called as agent of the company. Now directors as employees. So although directors are agents of the company, they are not employees or servants of the company. See, there is a lot of difference between directors and employees. Employees are those persons who are appointed by the company on a contract basis to perform the functions of to give the services to the company. So company, employee and directors are different things. But sometimes a director will also perform the functions of an employee. For example, a director is there who is given the additional responsibility of secretary of the company or additional responsibility of manager of the company. So here in this case, director, the person is a director and also the employee of the company. Twice, two positions he is occupying. In that case, we can say the director is an employee. But remember, every director is not an employee. Every director is not an employee. If he performs the employee's functions, then he will be called employee. Next one, directors as trustees. This is very important. The position occupied by director is that of a trustee. That means they are occupying the position of trust. That means they are handed over some responsibility, some property, some money to take care of on behalf of the trustee. So here, in certain respects, directors are in the position of a trustee for the company. How it is, how they perform as a trustee? Here you can see they are trustee of the company's money and property which comes into their hands. The company's properties, the company's money, the company itself cannot hold because it is an artificial person. So there should be somebody who should take charge of the money and property of the company. Here, directors. The company's property, company's money is in the hands of the directors. But remember, that is not their personal money. That is not their personal property. It is the property of the company. So they are the trustees. The directors are treated as a trustee for the money and property which belongs to the company. Secondly, of the powers entrusted on them. On the powers entrusted on them, they are the trustees. Because the company has to perform a number of functions, very important critical functions. The company cannot do the functions itself. So some natural person should be there. Here directors are the natural person. So company has given the powers to perform the functions of the company in the hands of directors. So directors are trustee for the powers which they got from the company. So directors are treated as trustees for the money, for the property of the company and for the powers entrusted by the company in the hands of directors. So directors stand in a fiduciary capacity to protect the interest of the company. So very important position directors are occupying because they are performing the functions on behalf of the company in the interest of the company shareholders. Then as trustees of the company, money's property, directors are accountable for their proper use. It is not indiscriminate right given to the directors. Directors are accountable for the proper usage, for the proper application of money and property which belongs to the company. They are accountable. So this shows that directors can be treated as a trustee of the company. Next one, directors as officers. Sometimes directors will be treated as officers of the company, particularly in case of any penalties are charged by the Companies Act. The Companies Act has given a number of do's and don'ts to the company. What the company can do, what the company cannot do, all these things are specified by the Companies Act. Suppose in some cases the company has violated some of the provisions of Companies Act, then the Companies Act has to prosecute, take legal action against the company. But how the company can be prosecuted? Because the company is an artificial person. The company cannot be prosecuted. So officer of the company will be prosecuted. So who is the officer of the company? Director. So if any wrong has been done by the company, then the responsible person will be officer. And officer are nothing but the directors. So in this sense, we can say the directors are officers of the company. Next one, directors as managing partner. Sometimes, very loosely, we can say directors will act as a managing partner. So directors are also sometimes described as managing partner because like a partner of the firm, they manage the affairs of the company. They are also usually important shareholder of the company. Actually, director is appointed, is a representative of shareholder. Actually, who has appointed? Normally, who has appointed the director? Shareholders. So shareholders are appointed just like in a partnership firm. In a partnership firm, all the partners will appoint some of the person as managing partner, and managing partner is given all the responsibilities to manage the partnership firm. Similarly, here also, in case of a joint stock company, the shareholders will appoint a person as director. So he is acting as a managing partner. But this position that he is acting like a managing partner is not exactly correct. However, there is quite difference between the position of a partner of a firm and the director of a company. A lot of difference is there between managing partner and director. So these points will be clear regarding the position occupied by a director. So in examination, you may get a question like, explain the position of director. So whatever I have explained, you just watch with full concentration. You can be able to understand. You can be able to write in examination confidently regarding the position of directors. Now, the next topic I am going to explain you is appointment of directors. Appointment of directors. Who will appoint the directors? Now, different situations are there where directors are appointed. Each situation I am going to explain you right now. First one, appointment of first director. When the company is incorporated, first directors have to be appointed. Now, who will appoint the first directors? The first director will be appointed by the persons who formed the company. Who will form the company? Promoters. The promoters will incorporate the company, will launch the company. So first director will be appointed by the promoters. The promoter will write the names of the directors in the Articles of Association, AOA. The Article of Association is the main document of the company. In that document, the promoters will write that our new company will have first directors so and so persons. Suppose, if the directors are not mentioned in the Articles of Association, then the law says the subscribers to the memorandum. The memorandum of association will have a clause, subscription clause. In that subscription clause, subscribers' name are written. Subscribers' name are written. So those subscribers will be treated as first directors if nothing is mentioned in the Articles of Association. Now the first directors will occupy the position of directorship up to the end of the first AGM, first annual general meeting. So after incorporation, the first annual general meeting will be conducted after a period of time. In that first AGM, annual general meeting, the first director can be replaced or they can be continued. So here I have given the first director are usually appointed by the promoters in the manner laid down by the company in the articles. Shall be the person whose name appear in articles. When no provision is made in the articles of appointment for first director, the subscriber to memorandum shall be deemed to the first director. If in the Articles of Association first directors are not given, in that case the subscribers given in the memorandum will be treated, will be deemed to be as first directors. The first director can hold office till the first AGM of the company. AGM, annual general meeting. So up to the end of first annual general meeting, the first director will continue the position office. Then when they are replaced by the directors appointed by the company at this meeting, in the annual general meeting, the shareholders, the members will appoint a new directors in place of the first directors. However, the members may appoint new directors to replace the first directors. So members will have the power. They can be able to retain the old first directors or they can be able to replace by new directors. Now, it is a usual practice to submit list of proposed directors. In reality, what will happen? At the time of incorporation, registration of the company, a list of proposed directors in writing will be submitted to the registrar of companies that these are the first directors who have given the consent to act as directors. And that consent in writing should be submitted at the time of registration. So these are the provisions regarding first director, appointment of first director. Now subsequent director, how they are appointed? Appointment of directors by the company. Actually, the company will have the power to appoint the directors. Directors are the representatives who are appointed by the shareholders. So every year a meeting is conducted called AGM, Annual General Meeting. In that Annual General Meeting, directors will be appointed by the members. So how many directors will retire every year? Here I am giving the provisions. Usually during AGM, directors should appoint by the shareholders. In a public company or a private company which is a subsidiary of a public company. Remember, every public company and the private company which is a subsidiary of a public company must appoint two-thirds, which is a subsidiary of public company, at least two-thirds of the total number of directors are subject to retirement by rotation. So according to the provisions of the Companies Act 2013, every year at least two-thirds, 2 by 3, two-thirds of the total number of directors should retire by rotation. Example, if the total number of directors are 3, the two-thirds of 3 is 2 directors. So 2 directors should be retired by rotation every year. So in the annual general meeting, at least two-thirds of the directors who are retiring should be appointed by the shareholders. And these directors are known as rotational director and must be appointed by the shareholders in general meeting. So two-thirds of the total number of directors are retirement by rotation, will retire by rotation. And the retirement by rotation will be reappointed by new directors in this annual general meeting by the shareholders or members. So first one we have seen, appointment of first directors of the company. Secondly, appointment of directors by the shareholders, members. Third one, appointment by directors, means appointment by BOD, Board of Directors. So Companies Act 2013 has given the power to the Board of Directors to appoint directors under certain circumstances. So what are the circumstances in which BOD, Board of Directors, will appoint directors? First one, additional director. Apart from the present directors, additional directors the company require. Already some directors are there. Maximum directors of a company 15. Already in the previous video I explained. But presently the company is having 10 directors. Now the company sees that the company requires some more additional directors. So this some more additional directors can be filled by Board of Directors. The appointment can be done by the Board of Directors, provided there should be the power should be given in the Article of Association. If in the Article of Association powers are given to Board of Directors to appoint additional directors, then only Board of Directors can appoint additional directors. So section 161(1), the Board of Directors, BOD stands for Board of Directors, can appoint additional director if provisions are there in the AOA. The provisions must be there in the Articles of Association. Then only the Board of Directors will have the power to appoint additional directors. These additional directors shall hold office up to the date of next AGM. If additional directors are appointed by the Board of Directors, they can occupy the office only for 1 year. That means up to the end of the next AGM, next annual general meeting. The number of directors and additional directors should not be more than the limit fixed. That means the total number of directors, which are present directors and additional directors, if you take the total, it should not exceed the maximum limit. The maximum limit of the directors are 15, so it should not exceed 15. Next, casual vacancy. The Board of Directors can fill the casual vacancy. What is casual vacancy? I have explained here. Any vacancy which takes place due to death or resignation. Death or resignation or disqualification or failure to hold the office for any reason other than retirement. The person is failing to report to the office of director. Then the rotation is called casual vacancy. That means any vacancy of director arises on account of death, on account of resignation, on account of disqualification or any other reason other than rotational retirement. The vacancy created is called casual vacancy, and that casual vacancy can be filled up by the Board of Directors. by the board of directors. So the public company or a private company which is a subsidiary of public company where a casual vacancy arises can be filled up by board of directors. So any public company or a private company which is a subsidiary of a public company can fill up the casual vacancy by the board of directors. Next, as alternate director, the board can appoint alternate director if it is given power by the associate articles of association of the company or by resolution passed. Alternate director, already one present director is there, but he is not coming to office, he is not performing his functions. So in place of that present director, one alternative director is appointed. Example, Mr. X is a director. He is not performing his functions because due to ill health or any other reason. So for that purpose, the board of directors can appoint an alternative director in place of X. Temporary director. So this director can be appointed only through a resolution passed by the general meeting of the company. A general meeting must be conducted, a resolution should be passed to make an alternative director appointment. The person in whose place alternative director is appointed shall hold at least for a period more than 3 months. Alternative director can be appointed only for the present director who is absent from his office for more than 3 months. If he is absent for less than 3 months, no alternative director can be appointed. If the present director is absent for more than 3 months, then only alternative director can be appointed. Last one, appointment of directors by the central government. The Companies Act has given powers to the central government also to appoint directors by the central government. So when this power will be exercised by the central government, Section 408 has given power to the central government to appoint such director. Such director must protect the interest of the company or the shareholders or the public interest. Sometimes the central government see that the present directors are doing the functions in such a way which is harmful to the company, to the shareholders or to the public interest. The company is doing wrong which will be harmful to the company, to the shareholders or to the public interest. If the central government see this, then the central government will appoint directors to the company. That means that appointment will be made by the central government. Such appointment must not be for more than 3 years. Maximum period 3 years only. Now, the main aim of such appointment is to protect the interest. Why the central government will appoint the directors? To protect the interest of the company, to protect the interest of the shareholders and to protect the interest of the public. So, for a period of which is oppressive to members or which is prejudicial. That means the present member are doing in such a way which is prejudicial to the company or its members. That's so I have explained you here about the position of director and the appointment of director. First, directors will be appointed by whom? Then every year appointment will be made by the general meeting members. Then directors, when the directors can appoint the meeting. This is the explanation I have given regarding appointment, position and appointment of directors. How? So we have discussed about the position of director and the appointment of director. Now in this video I am completing by taking up the topic of removal of a director. How a director can be removed. So that I am going to explain you now. Removal of director. A company may remove a director who is not a director appointed by tribunal under section 242. That means the company is having the power to remove a director provided that director is not appointed by tribunal under section 242 before the expiry of the period of his office. So only if the director is appointed by tribunal, the company cannot remove. Otherwise, a director can be removed by the company. So removal by shareholders. Actually, directors are appointed by shareholders. So directors can be removed by shareholders. So what is the procedure of removing a director by the shareholders? Section 169 of the Indian Companies Act 2013, the shareholders are given the power to remove any director of the company by just passing an ordinary resolution. Only the company requires to pass an ordinary resolution to remove a director by sending a special notice to the company. First of all, the shareholders who wants to remove the director must give a special notice to the company. This notice should be given to the company before 14 days, within 14 days from the date of AGM, annual general meeting. The special notice must be given 14 days before the AGM, annual general meeting. After receiving the notice, a copy of the proposed resolution must be sent to all the members and the concerned directors of the company. First of all, the shareholders who wants to remove the director has to give a special notice to the company at least 14 days before the date of AGM, annual general meeting. So after receiving the notice, the company will send this notice to all the members and also send this notice to that director who is to be removed. That is the procedure. Now, removal by tribunal. Tribunal can also remove a director. How? Under section 242, the tribunal may terminate or set aside or modify any agreement between the company and the managing director or any other manager. The director who is removed by the tribunal cannot claim or sue for compensation. So this tribunal will also have the power to remove the director or managing director or any other manager of the company. So any agreement between the company and the director or any agreement between the company and the manager, that agreement can be nullified by the tribunal, and who is removed by the tribunal cannot claim. The person who is removed by the tribunal cannot claim any compensation or sue the company against such for termination, and also he cannot work for the company in any managerial capacity for a period of 5 years. So when a person is removed by the tribunal, he cannot work for the company for the next 5 years because he is removed by the tribunal. Now, removal by central government. The central government also has the power to remove the directors. So under what circumstances the central government will remove the director? Now, a director can be removed by central government. Companies Act 2013 enables the central government to remove the managerial person from office on the recommendation of CLB. First of all, Company Law Board, CLB, must recommend to the central government. So on the recommendation of the Company Law Board, the central government will proceed to remove the director. The government can make a reference to the CLB when needed. So if the central government thinks that we have to study, we have to find out, scrutinize that this director should be removed or he should be kept, that case will be given to the Company Law Board. The Company Law Board will study the case, will study the exact real situation, whether it is prudent to remove or not. Then the power of central government can be exercised on removal of director if. So when the central government will exercise the power in removal of the director, 3 cases have been given. The first case, the managerial person is guilty of fraud, misfeasance or persistent negligence on carrying out the legal obligations or breach of trust. Central government unnecessarily will not remove the director. If the central government is having some proof that the person has conducted some fraud, some misfeasance or persistent negligence in the completion of their obligations, carrying out the legal obligations, or if the person has conducted breach of trust, if these are the cases against that person, then the central government will proceed to remove the director. Secondly, the business of the company is not conducted in agreement with sound business principles. Actually, company is a commercial organization. The company should be conducted by following prudent business practices. If the central government finds that this director is not applying the prudent commercial business practices in conducting the activities of the company, then the director will be removed by the central government. Thirdly, if the person has conducted business with an intention to defraud or unlawful activity, if the central government finds that the person is conducting his activities in order to defraud some people or in order to conduct some unlawful activities, then if these are the charges against that person, then the central government will order to remove that director. And then removal by the Company Law Board, the CLB, can also remove when an application is sent to Company Law Board to prevent mismanagement, if it may terminate or set aside any agreement of the company with the director. So these are the cases of removal of the director. So in this video, I have explained you the position of director, the appointment of director, and the removal of a director from the company. That's it. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. And give your comments on these videos. What I found is almost 50% of my viewers have not yet subscribed. Out of every 100 viewers, only 50 viewers have subscribed. Remaining 50 viewers have not subscribed. It gives me more enthusiasm when I see that my subscribers are increasing. I can be able to give more and more of better videos. So please subscribe if you have not yet subscribed. We'll continue the next topic in the next video.